Picture this: you walk into work on a Monday morning, only to find an email in your inbox saying your job is gone, effective immediately. No notice, no severance, no explanation. Just like that, years of hard work vanish in a single click. Sounds unfair, right? But here's the shocking truth: companies do this every single day, and not all of them follow the law when they do it. In 2025, mass layoffs are making headlines across industries: tech, retail, manufacturing, you name it. And while businesses have the right to downsize, they don't have the right to break the law. There are strict labor laws that protect workers during layoffs, and if your company violates them, the consequences can be massive. But the real question is, what actually happens if a company violates labor laws during layoffs? Can employees fight back? Can they get compensation? And how does the law step in? That's exactly what we're going to break down today. So, stick around, because by the end of this video, you'll know not only what your rights are, but also how to recognize when they're being violated. Welcome to Law Unwrapped, the channel where we take complex legal issues and translate them into everyday language you can actually use. If you've ever felt lost trying to understand what the law says about your job, your paycheck, or your workplace rights, you're in the right place. Today's topic is one that affects millions of workers: layoffs. In the past few years, layoffs have become almost routine, with companies citing restructuring, economic downturns, or even AI automation as reasons for letting people go. But here's the catch: not every layoff is done legally. Companies sometimes ignore or outright break labor laws, hoping employees won't fight back. So, in this video, we'll cover everything: what labor laws say about layoffs, the common ways companies break those laws, real-world cases where companies were held accountable, and most importantly, what you, as an employee, can do if you're ever in this situation. By the end, you won't just know your rights, you'll know how to use them. Let's start with the problem. Layoffs themselves are not illegal. A company can decide it needs fewer workers due to financial struggles, changes in the market, or even because new technology has reduced the need for human labor. But the way a company carries out those layoffs is where the law comes in. Imagine you're working at a tech company with 500 employees. Suddenly, they announce they're cutting 200 jobs effective immediately. The first question is, did they give proper notice? Under U.S. law, specifically the WARN Act, that's the Worker Adjustment and Retraining Notification Act, large employers must provide 60 days notice before mass layoffs. If they don't, that's a violation. Another common issue is discrimination during layoffs. Let's say a company disproportionately lays off older workers, women, or minorities. That can open the door to lawsuits under anti-discrimination laws. Layoffs must be fair and not target protected groups. Then there's the issue of severance pay. While not always legally required, many companies promise severance in their contracts or policies. If they suddenly refuse to honor it, that's a potential breach of contract. Finally, some companies cut corners by ignoring last paycheck laws, failing to pay workers their final wages on time, or not paying out unused vacation days when state law requires it. The problem is clear: when companies rush layoffs, they often ignore these protections. And when they do, the fallout can be huge, both for workers and for the company itself. Now let's break down the laws that apply to layoffs. First, the WARN Act. This federal law requires employers with 100 or more employees to provide at least 60 days advance written notice before a mass layoff or plant closing. If they don't, affected employees can sue for back pay and benefits for each day of violation. In other words, if a company lays you off today with no notice, they might owe you 2 months of salary. Second, anti-discrimination laws. Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, and the Americans with Disabilities Act all apply to layoffs. Employers cannot target people based on race, gender, age, disability, or religion when deciding who stays and who goes. If they do, that's grounds for a discrimination lawsuit. Third, contractual obligations. If your employment contract, union agreement, or company policy promises severance, the company must honor it. Refusing to pay could be considered breach of contract, and employees can sue. Fourth, state laws. Many states go further than federal law. For example, California requires payout of unused vacation days. Some states require faster delivery of final paychecks, sometimes on the very day of termination. Employers who ignore this can face penalties. Fifth, retaliation laws. If you spoke up about unsafe working conditions, filed a complaint about harassment, or demanded fair wages, your employer cannot legally include you in layoffs as punishment. That's retaliation, and it's strictly illegal. So, the legal framework is pretty robust. The problem is enforcement. Many workers don't know their rights, and companies take advantage of that ignorance. To understand how this plays out in real life, let's look at some examples. In 2023, Twitter, now known as X, faced massive lawsuits after its sudden mass layoffs. Employees claimed they weren't given WARN Act notice, weren't paid severance, and in some cases, weren't even given their last paycheck on time. Multiple lawsuits are still ongoing. Another case, in 2020, Hertz laid off thousands of workers with almost no notice, leading to WARN Act violations. Employees who sued won millions in settlements. Then there's IBM, which faced accusations of laying off older workers disproportionately to make room for younger, cheaper talent. That led to age discrimination claims. What do all these cases have in common? They show that when companies don't follow the law, workers can fight back and win. But it usually requires employees to band together, file lawsuits, or involve government agencies. The lesson: violations aren't just theoretical. They're happening, and companies are paying the price. So, what can you do if your company violates labor laws during layoffs? Step 1. Know your rights. Research WARN Act rules in your state, and know what protections apply to your industry. Step 2. Gather evidence. Keep copies of emails, notices, contracts, and pay stubs. If your employer violated the law, documentation will be your strongest weapon. Step 3. Talk to HR, but carefully. Sometimes mistakes happen, and HR can fix them. But if HR isn't responsive, don't stop there. Step 4. File a complaint. You can go to the Department of Labor or the EEOC, depending on whether the issue is WARN Act violations, unpaid wages, or discrimination. Step 5. Seek legal help. Many lawyers work on contingency, meaning they only get paid if you win. Don't assume you can't afford legal action. Finally, consider joining with others. Class action lawsuits often have more power than individual cases, and history shows they get results. So, what happens if a company violates labor laws during layoffs? The answer is clear: they face lawsuits, fines, and massive reputational damage. But more importantly, employees who know their rights can fight back and win. Layoffs are tough. They affect families, communities, and futures. But unfair and illegal layoffs? Those don't just hurt people, they break the law. That's why it's so important to stay informed. Because the law only works when people know it and use it. If this video helped you understand your rights, hit the like button, subscribe to Law Unwrapped, and share your story in the comments. Have you ever been part of a layoff? Did your company follow the rules or break them? Let's talk about it. Remember, knowledge is power, and the law is for everyone, not just lawyers.